Hey everybody, News Now Wyoming here. This is going to be a kind of a follow-up, but more of an update. People disagree with me on my take on what Riojas means for qualified immunity. I argue that it means absolutely nothing. We already had another case 20 years ago that said exactly the same thing. And so all they were saying is, yes, under extreme circumstances, qualified immunity doesn't exist without a prior clear precedent. People disagreed with me and said, no. It's now easier to fall under that doctrine. No, it's not, you guys. So the Supreme Court just denied cert on this case that we are about to review. They denied it, saying, no, we don't want to review it. We don't want to overturn the Court of Appeals of the Sixth Circuit. So in essence, they are saying that qualified immunity does not exist in this case. This case, taken in the light most favorable to the plaintiff, does not fall under qualified immunity, does not fall under that it should be obvious or common sense doctrine that was established 20 years ago and reestablished once again in Riojas. So please, quit telling me my analysis of Riojas is wrong. They are not removing qualified immunity. They are not making it easier for you to get to overturn qualified immunity. But let's take a look at this case. See if this, in your opinion, falls into that common sense doctrine. So here is Mr. Howse versus Stupid Cops and the city of Cleveland. I will admit, you guys, I do not know Ohio law at all beyond what I read here. I have studied a lot of the Texas laws, I know Wyoming laws, and I know Colorado laws. I have never had any intention of visiting Cleveland or Ohio, so I do not know their particular laws, and really Ohio is out of the news as far as this type of stuff for the most part. So this was argued and decided in front of 3 judges. This is not in front of the full court. We will take a look at the decision that they made not to hear en banc. But this was a 3-judge panel. And it was decided in March 18, 2020. Yes, that's before Riojas. So why do I use this to say Riojas doesn't matter? Because the Supreme Court just denied it after Riojas. Alright? We're going to ignore the boring part. So this was written by Circuit Judge Thapar. Chase Howse sued several police officers and the city of Cleveland for alleged violations of the Fourth Amendment. The district court dismissed the suit and we affirm. One summer night in 2016, he was walking home from a convenience store. Along the way, he says an unidentified Cleveland police officer approached and asked whether he had any weapons. Stop and frisk. Again, I don't know Ohio law. You have to, even if you've got stop and frisk in place, you have to have a reasonable suspicion before you stop and frisk. But, okay, let's ignore that. The John Doe officer then patted him down and searched his pockets. They searched his pockets, not just patted him down, but searched his pockets. Without a crime. Okay, he's not suing for that. But holy cow, he's walking. They stop and ask him, presumably with no reason, absolutely nothing. And they actually search his pockets. Not just pat him down, which again you need reasonable cause just to do a Terry stop. Terry stop is not a en banc or a full, you can do whatever the hell you want to do. That is not what a Terry stop is. Terry stop says you need a reasonable suspicion to stop somebody and ask them and search them. You have reasonable suspicion of a crime, that a crime has occurred, is about to occur. And him walking home from the convenience store probably does not fall into that. But, again, he doesn't sue for that. But already I hate all these cops involved. When Howse got home, he began climbing the steps on his front porch. The parties dispute what happened next. Now, they are going to go into both versions of the story here, but please note that for the purposes of the appeal, for the purposes of a request to dismiss a case, they must take all facts and the evidence of the non-moving party. So the defense is saying we want to dismiss the case. They are the moving party. So all facts that are questionable, that go against each other, must be taken in the light most favorable to the plaintiffs. But we are going to read both sides of these stories here. As Howse tells it, several men, two of whom he later identified as officers Thomas and stupid cops, pulled up in an unmarked vehicle. Middaugh asked Howse if he lived at the house. Howse replied that he did. Middaugh asked Howse if he was sure that he lived there. Are you sure you live there? He said something like, yes, what the F? That seems like an appropriate response. You come to me with a stupid question that you have no legal basis to be asking? Screw you. Alright, you're going to get about the same response from me. That prompted Middaugh to comment that Howse had a smart mouth and a bad attitude. He then got out of the car, walked towards the porch, and asked Howse yet again if he was sure he lived there. And again, Howse responded yes. So contempt of cop is the charge. Things escalated from there. Middaugh told Howse to put his hands behind his back and that he was going to jail. Howse disobeyed. So they are in an unmarked vehicle. They do not say if they are wearing plain clothes or in uniform. Howse disobeyed his command to put his hands behind his back. Instead, Howse yelled. Again, this is what Howse says happened. Yelled that he hadn't done anything wrong and that he lived at the house. Middaugh ran onto the porch, grabbed Howse, who at that point was screaming at the top of his lungs, and threw him down. When Middaugh was on top of him, Howse realized that Middaugh was a police officer. So again, I don't know if they were in uniform. I was trying to find any body camera of this incident, but of course, there aren't any that I can find. If somebody knows where I can find some body camera, I would love to have it. I would. I want to see exactly what I like the body cam. Cameras don't lie. People do. Middaugh, with help from Howse, then tried to handcuff Howse. But Howse, in his own words, was resisting arrest by screaming and stiffening up his body. Howse said he never tried to hit, push, or fight with the officers. And he claims that he didn't do anything that would be considered offensive to the officers. Yes, contempt of cop is offensive. Okay, don't do it. Contempt of cop is bad. Bow down to your masters. At this point, Howse's mother, who owned the house, showed up. She had heard some commotion and rushed to the front porch. When she arrived, she saw a chaotic scene. A man in dark clothing straddled Howse, and another man struck Howse with a closed fist, which caused Howse's head to strike the porch. She asked the men, who she later realized were police officers, so again, don't know if they're wearing uniforms, to stop beating her son. She kept explaining that he lived at the house. After things settled down, the officers put Howse in a police car and took him to jail. Okay, so again, everything we just heard is what the Court of Appeals has to consider to dismiss this case. And the district court has to consider as true. Everything he just said is true for the basis of this appeal and the original order to dismiss. But we're going to go ahead and go over the officer's story because why not? They get a say too, right? Stupid cops. The officers tell a different story. That night, Howse and Middaugh, along with another officer, were patrolling the area where Howse lived, an area known for violence, drugs, and gang activity. While driving in an unmarked vehicle, they saw Howse lingering suspiciously on the front porch of a house. He looked nervous when he saw the unmarked vehicle. Middaugh thought the house was vacant because it appeared to be boarded up and there were bars on the doors. Based on his training and experience, Middaugh suspected that Howse might be engaged in criminal activity. Based on his training and experience, don't you just love that crap? So Middaugh asked Howse whether he lived there. F you, officer, I don't care. Okay. Yes, let that be part of the court record. I said that over and over and over again. I'm not answering your stupid questions unless you can prove that I've committed a crime, kiss my bloody ass. It's about to be bloody because you're about to beat it. But, alright. Howse said he did. Medad wanted to investigate more, so he got out of the car, walked toward Howse, and asked him if he was trying to break in. Medad doesn't remember exactly what Howse said in response, but he does remember that Howse said F along with some other words. Howse, for what it's worth, recalls Howse saying, F you and leave me the F alone. Both appropriate responses to police poking their nose where it doesn't belong. When Medad reached the front porch, Howse clenched his fist and squared up into a fighting stance. Medad, afraid that Howse wanted to fight, told Howse to put his hands in the air. Howse ignored that instruction and instead motioned toward his pockets, which prompted Medad to grab his arm. Stupid cop joined other stupid cop and tried to restrain Howse, who was grabbing at the officers and flailing around. He struck Howse struck the stupid cop in the chest. He also tried to rip off his flashlight and handcuff case. So Medad used a leg sweep to take Howse to the ground. Even while on the ground, Howse resisted the officers by burying his hands underneath his chest. Eventually handcuffed him and put him in a police vehicle. It wasn't until House's mother showed up, the officers claimed that they found out that Howse did live at the house, and they just screwed up royally. And here's where they talk about the fact that they do have to consider in the light most favorable to the plaintiff. Okay, we're going to skip that because I already told you guys that multiple times. Keeping that principle in mind, we can continue with some undisputed facts. After Howse was booked into jail, Medad signed a complaint charging Howse with assaulting a police officer. Howse and Medad then wrote up use of force reports detailing what happened on the front porch. These reports said that Howse resisted arrest and struck the officers. What were you under arrest for, they may ask? Nothing. He was under arrest for being on his property that he was allowed to be on. How can you place somebody in arrest if you don't suspect them of, if they haven't committed a crime? I mean, okay. These reports said the Howse resisted arrest and struck the officers. After a few days, Howse posted bond and was released. Later, a grand jury indicted him on 2 counts of assault, along with 1 count of obstruction of official business. But the state eventually dismissed the charges. Howse then sued Howse and Medad under 1983 for violating his 4th Amendment rights and for committing assault and battery under Ohio law. He also sued the city of Cleveland, claiming that the city was responsible for the 4th Amendment violations. The district court granted summary judgment for the defendants. The bill followed. He brought 3 claims against the stupid cops. Claim for excessive force under 4th Amendment. Claim for malicious prosecution under the 4th Amendment. Okay. Yeah. And then a claim for assault and battery under Ohio law. Again, I don't know Ohio law. Howse first argues that Howse and Medad violated the 4th Amendment when they stopped him without reasonable suspicion and used excessive force during his arrest. In response, the officers asked for qualified immunity. So it talks about the 2 prongs, and it once again ignores a 20-year-old case. So they're going to begin their analysis with the 2nd prong. They don't have to begin their analysis with if they violated the constitutional right. The Supreme Court said we don't have to establish a right in future proceedings. All we have to do is look to see if it was clearly established. So under these newer rules from the Supreme Court, they never have to clearly establish qualified immunity, or they never have to establish whether or not a right was violated. So officers can keep doing the same thing over and over again. Let's ignore. So in this case, what if this wasn't clearly established, but it does violate their rights? They don't have to establish that it violated the rights. So the cops can do the same thing 1,000 times in the future, and it still doesn't fall under clearly established because none of them will establish it. This is BS. They need to establish it. If they're not going to at least give it to that person, they should give it to the ones that the cops do it to next, because the cops are going to do it to somebody else. You need to put the cops on notice that their behavior is inappropriate, and that we are going to hold them accountable. So clearly established means that, you know what, I'm not going to read that. Yeah, I'm going to ignore all this stuff because we've gone over it in the past. We consider his claim. Howse argues that the officers violated his clearly established right to be free from unreasonable government intrusions, but that frames the clearly established test at too high a level of generality. The law must be specific enough to put a reasonable officer on clear notice that his conduct was unlawful. The right to be free from unreasonable government intrusions is too vague to do that. Instead, we must examine the particular situation, whether the law clearly established that their conduct was unlawful. To answer this question, we must ask whether every reasonable officer would know that law enforcement cannot tackle someone who disobeyed an order and then used an additional force if they resisted being handcuffed. Importantly, this question asks about the lawfulness of conduct under the Fourth Amendment. And in that context, the Supreme Court has stressed the need to identify a case where an officer acting under similar situations was found to have violated the Fourth Amendment. Without such a case, the plaintiff will almost always lose. Howse hasn't identified any case that addresses the conduct at issue here, and we aren't aware of any either. However, Howse cites a single case in support, Terry v. Ohio, but that case does him no good. Terry held that the search did not violate the Fourth Amendment because the law enforcement officer reasonably believed that the suspects were engaged in criminal activity and might be armed and dangerous. It has nothing to do with excessive force, so Terry doesn't clearly establish that law enforcement can. And so here's also another problem. Why Riojas really doesn't matter. We'll see 2-3 years from now if it does. But they aren't bringing up the prior case from 20 years ago in their arguments. So, plaintiff attorneys really need to get on the ball there, right? Because the alleged unlawfulness of the officer's conduct wasn't clearly established, the officers are entitled to qualified immunity. The defendant concludes otherwise after it frames the question as follows: whether it violates a clearly established constitutional right for an officer to throw a person to the ground in order to arrest that person without probable cause. Of course, it's true that an officer cannot arrest someone without probable cause. But it's also true that an officer doesn't need probable cause to stop someone. Reasonable suspicion is enough. Thus, the level of justification depends on whether the officer is carrying out a stop or an arrest. But you can't arrest me for resisting arrest if you aren't placing me under arrest. If I'm resisting being detained, but that's not a crime. In most states, that might be a crime somewhere. But in Texas, Colorado, and Wyoming, the three states I do know a lot of the laws, resisting arrest is exactly that. Resisting arrest. It says nothing about a detainment. It says nothing about resisting being handcuffed for a stop. None of that. I don't know Ohio law. I guess I'm going to be learning some Ohio law because I really want to know. Can you be placed under arrest for resisting arrest if you're not under arrest at the time? If they only want to detain you. There's a big difference there. So the level of justification depends on whether the officer is carrying out a stop or an arrest. But if I'm allowed to resist you because it's not against the law for me to resist you, then I can resist you. The mere act of handcuffing doesn't transform a stop into an arrest. I disagree with that. The Supreme Court has ruled that. That is a stupid ruling. You put me in handcuffs, I'm under arrest. That's because an officer may temporarily handcuff someone during a Terry stop, so long as the circumstances warrant that precaution. So it isn't obvious that the officers were effectuating an arrest rather than an investigatory stop when they tackled and handcuffed Howse. The dissent cites Santani to show that the officers arrested Howse when they initially threw him to the ground. But Santani cuts against the dissent's conclusion. That's because Santani says that an arrest generally doesn't occur until the officers physically remove the suspect from the scene. Of course, the officers hadn't removed the Howse from the scene when they initially threw him down. So that would mean the officers didn't need probable cause until they removed him from his home and took him to the station. This is all very circular. We're going to arrest you for resisting arrest, but you weren't under arrest at the time. But the appeals court says that's okay. You can arrest somebody for resisting arrest, but even though you weren't under arrest. Malicious prosecution. Committed malicious prosecution when they helped prosecutors charge him with 2 counts of assault and 1 count of obstructing official business. To win on that claim, Howse must show, among other things, that officers helped start a prosecution against him without probable cause. Probable cause exists when there are enough facts and circumstances to make a reasonable person believe that the accused was guilty of the crime charged. There's enough evidence for a reasonable person to believe that Howse obstructed official business. Someone obstructs official business, and again, I don't know Ohio law, when he acts with the purpose of obstructing or delaying an officer from performing a lawful duty, and he actually hampers or impedes the officer. And that's according to the Code of Ohio. Texas law and Wyoming law requires a lot more than that, but if Ohio doesn't, okay. Ohio courts have interpreted this crime broadly. For example, someone may be convicted if they make it more difficult for law enforcement to gain control of a situation, or to interfere with an attempt to arrest someone. Here, Howse himself admitted that he tried to make it more difficult for the officers to arrest him, but not to arrest him, to put him under... He's not under arrest at that point. You can't, again, that's circular logic. You can't arrest somebody for resisting arrest if they aren't in fact under arrest. I mean, that's stupid. That's a stupid argument to make. How do you even try to make that argument? I understand now, if Ohio's law is worded this way, why they can now place him under arrest for obstructing official business, if that is in fact what it says. But again, yeah, circular logic, because there was probable cause for that charge. Oh wait, no. Before they put hands on him, before they touched him, was he obstructing them proceeding with their official business? Are you sure you live here? And he said, F you. Is that him obstructing? F off? Stuff like that? Is that them obstructing? No. So, you aren't... Wow. They skipped a whole part of this encounter here. They skipped an entire part of this encounter here to get to this conclusion. And that's BS. Although we call it a claim for malicious prosecution, that's a bit of a misnomer. After all, our circuit doesn't even require showing of malice to succeed on such a claim. It's really a claim for an unreasonable prosecutorial seizure. He can seize someone so long as he has probable cause that they have violated the law. So in this case, they have probable cause because of the above aforementioned crime, but they didn't have very, very circular. and making it almost impossible to prove otherwise. So we're going to skip the rest of that. Assault and battery must show that the officers acted with an intent to cause harmful or offensive contact. Such contact occurred that he thought such contact would occur. That's assault. Once again, claim they're immune from suit. And presumption of immunity that can be overcome only by a handful of circumstances. Yeah, we're not going to focus on the claim, the Ohio claim. It's not really too important. 1983 claim against City of Cleveland. Monell would be difficult. I don't see a Monell claim here. A Monell claim to overcome the city's burden would have to show that this was due to policy or some other decision made by the city. And none of what happened on that night really seems like it would be part of written policy. Maybe unwritten policy, but not written policy. Policy and practices. So I don't see a Monell claim being overcome here. So we're going to skip the city because we know already that they appealed it, and so the city did win. And so the dissent is also gonna, so we've already read the important parts of the dissent. Then they took it and tried to argue en banc, which means the entire panel instead of, or the entire Court of Appeals of the Sixth Circuit instead of just the three. And they denied en banc. Received a petition for a rehearing en banc. The original panel has reviewed the petition for a rehearing and concludes that the issues raised in the petition were fully considered upon the original submission and decision. The petition then was circulated to the full court. Less than the majority of the judges voted in favor of a rehearing en banc. Therefore, the petition is denied. The dissent on that, I respectfully dissent from the court's denial en banc hearing. The panel's holding with respect to malicious prosecution claims, which adopts a one-size-fits-all approach to false arrest and malicious prosecution, is a precedent-setting error of exceptional public importance. It is at odds with Supreme Court precedent, see Walls v. Cato, and our precedent, see Jacobs v. Alem, and it fails to engage with the many compelling reasons offered by our sister circuits for declining to adopt such an approach. But I dissent for a second reason. In qualified immunity, we have long held that a plaintiff's right must be defined with careful attention to the specific factual circumstances of the case. And yet, in framing Howse's right in this case, the panel fails to account for his suspected criminality, none, location, his home, or conduct truthfully answering questions. Yes, with contempt. I will not dispute the fact that the guy probably answered with contempt. He showed contempt for cop, and that is why he was arrested. Detained. He was arrested for failure to be detained, or resisting detainment. We are often confronted with troubling allegations of official misconduct that result in no liability because the plaintiff defines his perceived right too broadly. While these difficult cases frequently raise grounds for reasonable disagreement and rarely warrant en banc rehearing, our cases are unanimous in holding that a plaintiff's right must be carefully defined. When we depart from this well-accepted requirement, we erode one of the greatest sources of confidence in the judiciary, the consistency of our jurisprudence. So that was the dissent on the rehearing. And then, of course, the Supreme Court just denied cert, which means they are not going to hear the case. They are not going to consider any of the, whether it's common sense that officers can't assault somebody on their own property for not violating the law. That's not something they are allowed to do. There are a few other claims I would have claimed if I were this guy, and I would be a lot more specific. I would bring that contempt of cop in. I would argue that contempt of cop, that they got upset and wanted to detain me because I said F you, which is unreasonable. Um, yeah, there are other claims I would have gone with. Yeah, that malicious prosecution one I think was a weak one. I could see the argument, but I think it is a weak one. And then the other claim, again, ignoring the Ohio claim. Where do they actually claim for excessive force under the Fourth Amendment? Um, that that resulted from his using his First Amendment. I would have definitely been afraid. Yeah, if this were me, and again, hindsight 2020, okay, uh, I would have been bringing other claims, not just Fourth Amendment. I can understand why they did it, but also knowing the way that qualified immunity is taken by the courts, I would have been a lot more specific on it, and probably raised some different claims, brought in other claims on that. So there we go. What do you guys think? Is this? What do you think about the case? What do you think about Riojas? What do you think about the Supreme Court saying no to this case completely? So this action here is what is currently in place here, right? Nothing else matters. Only this matters. This is final. All right. Have a great night. Let me know in the comments below. Bye.